Yes, so even if you can hear me, you on this platform, you're representing the views of the youth. As a Ghanaian youth, do you see that this move by the executive is in line with accountability, or it's simply an executive overreach?
Thank you very much. Good evening to the speakers and to the listeners. Well, to answer your question, I believe we have to do a bit of the history in terms of our constitutional dispensation. What we have to look for, probably, so I tried to do a little work trying to look at the various constitutions that we've had. And clearly, if you look at the first constitution, that's the 1960 constitution, you look at Article 45. It clearly gave the president the power to remove justices of the Supreme Court or the Superior Court, and by getting a two-thirds majority in Parliament. And that was the provision that, the famous removal of the Chief Justice, then Sir Kukosa, and the others. Nkrumah exploited that. So he had the power, he had the authority under the constitution to do same, and he did what he has to do. So coming into the 1969 constitution, clearly looking at the memorandum, that was one of the things that was being chastised. So cleverly, the 1969 constitution, what it did was that it has to put in measures or procedures to remove Superior Court justice and the Chief Justice as well. And we have that semblance in our 1992 constitution. But if you look at the composition under the 1969 constitution, clearly under Article 116, what it did was that the composition of the committee to hear the petition against the Chief Justice so appointed by the President was supposed to have made up by 3 justices of the Supreme Court and 2 other persons who are not, justice or lawyers or not members of the Council of State. We had same provision under the 1979 constitution, same, but cleverly under the 1992 constitution, which in fact the reasons and the process or procedure is virtually same under the 1969, 1979, and 1992 constitution. But what is intriguing is that if you look at Article 1466, you realize that the composition of the committee to hear the case now is supposed to be heard by 2 justices of the Supreme Court and 3 other persons who are not, judges, lawyers, and not members of the Council of State. I believe that if you look at the 69-79 constitution, made up of 3 justices, because to remove a Chief Justice, which is an arm of government, I believe that was a very fair representation in terms of the committees that we had. But now, under the 1992 constitution, you have 2 justices of the Supreme Court and 3 other persons who the constitution says that they cannot be the justice of the Supreme Court, lawyers, and not members of the Council of State. I found it a bit intriguing because I believe that as the Chief Justice should be tried by persons who are, so to speak, her peers. And persons who sit in the Supreme Court are most closely related to her duties and to her actions. So they will be able to have a better eye view of what she's supposed to do, what she's not to do. And when hearing such a position, because this basically becomes matters of law. And like I rightly said, removing an arm of government, it shouldn't be treated lightly for us to have 2 ordinary persons try to look at it. I think the composition, we have to relook at it well again. But in all this discussion, I believe what has transpired over the period is for us to relook at this kind of procedure. Because clearly when we're being taught, we were taught that, there's independence of the judiciary. Yes, even though Article 125 would, protect them. However, if you look at the procedure, we thought it was something which was unthinkable. And I think Doc made reference to the removal of Charlotte Osei. Then we realized that, I think the framers didn't contemplate that this can be a very easy way of removing any Chief Justice, which is the 3rd arm of government. Okay, so I think that in all this discussion, as has been rightly been said, law should be a tool for social re-engineering. But all this discussion is coming up to the point that Ghanaians are getting awake to look at this kind of procedure and process. And I think what we have to do is to really look at these provisions again, so that we, as it were, get off the hands of the executive from this kind of process and find some independent process of trying to either even appoint judges or to remove the judges. So yes, if you are saying there's kind of executive interference or kind of incursions into the removal of the CJ, well, you can say so, but this is the law. This is what the Constitution provides for us, and clearly, in any way to remove any chief justice under current dispensation is to go through the same process. So I believe that for me, it's a wake up call for us to look at it again, because rightly so in the general discussion, we've heard persons, I mean, from the other side, I mean, that's the MPP saying that, okay, when we also come, we also remove the CJ. And right, what happened in the Charlotte Osei case, whereby persons of the NDC say, okay, if you get power, we also remove the current EC. So now, I think it's a wake-up call for us to look at this very well in terms of constitutionally bodies, in terms of their chairpersons, and in terms of the judiciary. How independent are they? How independent can they be if their appointment and their removal is, so to speak, in the hands of the executive? Then clearly, everybody, if I'm a justice of the court, I might be tempted to obey my appointer, which shouldn't be the case. So I think, yes, there's a bit of executive influence in here, but like I said, this is what we have under our constitution, save for we amended this provision. Thank you very much.
Thank you so much, Sefa. I would bring in Blaque, but before Blaque comes in, I want to quickly bring in our brother Manasseh Azuri. Thank you for joining us this afternoon. I'm sure you've been following how the discussion is going. So just as I asked Sefa, I would also want to ask you, do you see this current situation as accountability or simply an executive overreach?
Well, thank you very much for this opportunity. I see an executive overreach and the executive in a way controlling the judiciary, but not exactly what is happening now. There is a saying that when you find two men fighting, you ask what happened the other day and not what is happening now. We know what is happening now, and it is not in a vacuum. If things had gone right in the past, we would have assumed that this is just a normal process. But for a long time, the judiciary has come under serious scrutiny. And those who criticize the judiciary did not do that out of place. And I must also say there are hard-working judges at all levels. But the leadership of the judiciary and the Supreme Court haven't done themselves any good. Madam Mary mentioned delays in cases. And in my book, The President Ghana Never Got, there is a chapter called The Judiciary, an Accomplice of Akufo-Addo. And I said that because when you look at what the judiciary did within that period, it gave the executive the go-ahead to do some of the things they did. And sometimes it's not just about the ruling, but how they preside over some cases. The Domelevo case, the Auditor General was hounded out of office unconstitutionally. That case could have taken 2 weeks to resolve. It took the judiciary or the Supreme Court 3 years. That case was in court before the election. The election came, and then the Jati Kwesi case started from the High Court, went to the Court of Appeal, went to the Supreme Court, and got finished before the Supreme Court interpreted the Domelevo case. 3 years. The NDC had issues with the constitutionality of some of their procedures in Parliament. During the passage of the e-levy, they went to the Supreme Court. It's been 3 years. The Supreme Court is here to rule over that matter, and then the law has been repealed. So just like the Domelevo case, even if the ruling comes, it will be of no effect. Now you have similar cases of the MPP going to court in Parliament over some the Speaker's decision to ask some people to go home. It took only 3 weeks. And then recently, when somebody petitioned the suspension, against the suspension of the Chief Justice, it took less than 2 weeks. I'm saying this to make a point that when you have a judiciary that is so inconsistent in the timing or its timelines, and it seems to follow a particular trend, either for or against a particular party, you don't expect reasonable people to just say, well, they are doing their work, so they are not perhaps under any influence. The other most disturbing aspect is even the Domelevo case. And I'm mentioning these cases because I have a perception that for a long time, the judiciary has been pandering to the whims and caprices of the executive. And I am not doing that because I'm influenced by the political parties saying this is a unanimous FC. There are specific cases. Osafo Mafu and then Kroll and Associates did a contract that had so many issues. That contract didn't have PP approval, the work they were supposed to do. They started even paying before, a whole lot of irregularities. It was an international contract, no parliamentary approval, and all of that. They surcharged Osafo Mafu and his people, and they petitioned in court. The case goes to the court, High Court, and then it gets to a very contentious point. The Auditor General had requested information, and then they refused to give that information. Then at the High Court, the explanation given or the excuse given was that that information was of national security. It had national security implications. So it couldn't be given to the Auditor General. The Auditor General said, no, this couldn't be the case because you have indicated that that same audit you couldn't give to us was shared with Cocoa Board, IOCO, and other institutions. So the High Court says this should go to the Supreme Court for an interpretation on whether or not this was national security in nature and exempt from being given to the Auditor General. So two things. If the Supreme Court had ruled that the information was exempt, then Osafo Mafu and his people had a case. If the Supreme Court ruled that no, this information which you've shared with all other institutions couldn't be withheld from the auditors, then back to the High Court, Osafo Mafu and his team would have been found wanting as to why they refused to give that information during the audit. And it's even an offense, according to auditors, to withhold information from auditors. Now the Supreme Court does something very interesting. Instead of ruling on the substantial matter, it forces the Auditor General to go and inspect the information. That was not why the case was referred to the Supreme Court. It was referred to the Supreme Court to determine, is it exempt or not? And now they say, no, we will not determine that. Go and look at it. And the moment they say they should go and look at it, the president comes in to say the Auditor General should go home. The following day, the person the president appoints says, so I've looked at it, everything is perfect.
So then I would bring in Blaque, and then we are still dwelling on the accountability of this whole issue, or whether it's an executive overreach. So briefly, if you can just let us know your view on this one. It seems you've lost Manasseh.
Okay, and happy Friday, everyone. And please, can you hear me very clearly?
Loud and clear.
Good, good. So, first of all, I would like to thank you guys for once again hosting this space and giving us the opportunity to share our thoughts on current affairs in the country. I don't think it's an executive overreach. And before I go into it, the previous panelist has elaborated on the perception of the judiciary. There was a research poll that came out that named the judiciary to be third most corrupt institution in our country. And so the distrust for our judiciary doesn't stem or didn't start from the process of removing the Chief Justice. And I believe if we all agreed that we should be guided and guarded by the Constitution, and a process have been activated that is in strict compliance with the Constitution, then any perception or any insinuation that it's an executive overreach or an attack on the judiciary is rather to be seen as unpatriotic. And I'm saying that because the executive has followed the constitutional provisions in Article 146 to the letter. And so far, nobody has been able to tell us that the president has violated any provisions of Article 146. To the extent that I believe the president has gone beyond what Article 146 tells him to strictly do and given the contents of the petition to the suspended Chief Justice before prima facie is established, and then allowed her more time than she requested to file her response and subsequent ones. So, in my opinion, the president's consistency cannot be questioned because the taxpayers are the one for whom all three branches of our government works. When a Ghanaian who is a taxpayer believes any of the heads of these institutions have violated or has committed offenses and they believe their removal should be activated and they go through the constitutional provisions, it is binding upon the president to follow the constitution to the letter. President Mahama did that for the former Shrag boss when the petition was filed by Honorable Anodompre and Richard Nyama. And consistent to his actions and respect for the constitution, he followed the same procedure this time around. So I think the executive should not be rolled up into this assumption. Now, when it comes to the executive, the judiciary itself, the Chief Justice is not a representation of the judiciary. The judiciary is a title and the CJ is a billet. And that is why, in the absence of the Chief Justice, the suspended Chief Justice, there is an acting Chief Justice and our judiciary is functioning well. So if there is a prima facie that something needs to be answered by the suspended CJ, then I believe it's in the right procedure. And as far as I'm concerned, she has not been removed. Before Manasseh got cut off, we were here when Ghanaians have expressed their dissatisfaction with certain decisions the court have made. And I think Brother Eben that spoke earlier, he said a couple of things that I disagree with. Imagine that the removal of the president requires a process in, I believe, Article 62, whereby 2/3 of parliament has to vote for his removal. Imagine if you put it in a way that 2/3 of the minority, or 2/3 of the majority of the NDC have to vote to let him out in the last parliament where it was 137, 137. I'm saying that because if we are saying 3 judges should sit on the council and then 2 non-judges, how are you expecting 3 judges from the corridors of the CJ herself or himself to vote against them? That's like asking for majority of the members on the Council of State and a minority of the general public to vote for the removal of the president. Yeah, in literal terms, we can say they could be independent minded, but we can't decouple politics from our constitution because we are running a multi-party democracy, which comes with, politics. So I believe that it is right, as the constitution is saying now, for minority of the panel members to come from the general public other than the judiciary. So I think the processes are ongoing. And somebody mentioned the demonstration. I was taken aback a little bit with the demonstration because if the protection of the judiciary can be achieved if the president violates the constitution, then I find difficulty with understanding where we are as a nation, whereby we are asking the president not to exercise discretion given to him by the Constitution. And discretion can be exercised one way or the other in compliance with the provisions, and none of that has been violated. But we have a demonstration that is seeking to tell the president to not do the right thing. That is where my confusion is. But all in all, the reputation of the judiciary has been tainted a long time ago. I mean, Anas's expose, tells us the kinds of gifts that judges receive, goods and things of that nature, to sway judgments one way or the other. We have seen even judgment against Anas in Ghana's courts, where judges are impugning the integrity of Anas, and Anas gets to a court in other jurisdiction, and it's not only vindicated but is awarded. We are seeing cases where judges of the Supreme Court are empaneled within hours of members of parliament filing. And then another case of a member of parliament filing to put an injunction on the passing of the e-levy, and maybe 2-3 years on till now have not been heard, right? So the perception of judiciary has been tainted for a long time. And the removal of the Chief Justice, that process should not be affiliated directly with the tainting of the judiciary as far as their conduct. And I also hope we don't misconstrue independence with accountability, because I think that's what we are doing now. We want to exude certain class of people from accountability in the quest for their independence. So that'll be my initial comment. Thank you.
Thank you so much.